We will now switch from the practical aspects and clear-cut guidelines addressed by Rod to the zone of legal ambiguity in order to address the legal obligations that an owner has engaging in such areas of concern. First, I will try to deal with the BIMCO GuardCon and, the legal components for employment of the private maritime security companies known as PMSCs in West Africa. The decision as to whether an owner will employ guards is a pure operational one. But what we need to bear in mind is that an owner has to comply fully with the flag state laws, but also the local applicable laws. BIMCO GuardCon was created, the GuardCon contract by BIMCO, which was also subsequently amended by the international group of clubs in order to accommodate the needs of the Gulf of Guinea region. GuardCon intends to provide contract certainty and to make it simpler and quicker for an owner to put appropriate security arrangements when this is needed. Such security arrangements are envisaged to have unarmed PMSCs moving alongside with armed local approved security guards. Of course, the use of GuardCon is not a recommendation to use armed guards. This should not be interpreted by any way like that. And such a decision will need to be taken after a proper risk assessment. Then let's look more carefully at BIMCO GuardCon. My first point is that owners have potentially legal liabilities for guards on the ship, even if these guards have been contracted and put on board by the contractors. So the owners should not give away their options over the selection and exercise due diligence the selection of these security companies. Moving now to the second point, the contractor should recognize the master's ultimate responsibility for safe navigation and overall command and authority under solace and in general overall safety of the ship. These issues can be addressed by reference to the agreed rules for the use of force, which is usually amended the Appendix B to the GuardCon contract. The third point is that BIMCO GuardCon should be reviewed to ensure that armed and unarmed guards provided by the local military forces are also included in the contractors group. Last but not least, this is a very important point, is that the PMS insurance should include contractual indemnity cover for possible exposure as well as public and employer's liability. And this insurance should also include the cover for the local military security guards. There is such insurance in the market, so you need to have it before, when you are contracting on BIMCO GuardCon. Now let's look at the Nigerian position, which is highly complicated. Special caution must be given as to whether any foreign security guards can be engaged when we trade to Nigeria. And this is because earlier in the year, in February, the Nigerian Maritime Administration and Safety Agency, NIMASA, issued a notice that ships calling at Nigerian ports with foreign security guards will be detained. The Nigerian Navy has declared the shore authority for the country's territorial waters. The only legitimate method of security protection in the area and in the Nigerian waters, it is believed at this moment to be the escort services provided by the Navy itself. I have to stress, however, that there are some PMCs companies that they purport that they do have memorandum of understandings with the Navy for the provision of security. But unfortunately, the implication of such MOUs is not clear to the owners. There has been an indication recently that the Chief of Naval Staff of Nigeria will be coming out with a new policy as to the role of the PMCs in the maritime sector. Lastly, with the Ghanaian position, in Ghana, again, the government reportedly has given license by way of a memorandum of understanding to one particular PMC in order to allow armed guards to provide security on board commercial ships, again in the Ghana's economic zone. In collaboration, the same pattern with the Ghana Marine Police. So one important point to bear in mind is that keep abreast of developments in the region, as the position is far from clear and it changes constantly depending on the policy within the various jurisdictions of the nations in the Gulf of Guinea. Next, let's see charterers' orders. We are often very often asked by our members and owners, can I refuse charterers' orders and not transit a high-risk area, including the Gulf of Guinea? And this will depend from the charter party terms and the bill of lading terms. That is the starting point. I don't want to bore you with details and legal details, so I will address and mention an interesting case that we had back in 2001, where the ship has arrived fully laden offshore Cotonou to discharge some of her cargo by way of a series of STS transfers. After a month, armed pirates boarded the ship and fired shots. The pirates left the ship after 7 hours of stay on board. None of the crew injured during the incident. Following the incident, the ship drifted off offshore, and owners subsequently refused to continue with STS operations. Finally, after a month and a half of negotiations, owners agreed to the STS discharge under reservation of the rights. But they have refused subsequent similar voyage instructions and orders by the charterers. The ship was subchartered, and the subchartered have treated this refusal as a repudiatory breach and proceeded with the termination of the charter. But the head charter remained in place. Notwithstanding that the head charter party did remain in place, charterers subsequently brought a claim against the owners as a result of the refusal to comply with the order to continue cargo operations. Owner's argument was, and continue to is because the case is developing to litigation, high-power litigation in London, is that they were entitled to refuse the charter's order because Cotonou was not a safe place for the ship to conduct STS operations. In owner's view, it was well justified to refuse consent to discharge in view of the risk of injury, of death to the crew, hijacking or damage to the ship, as well as cargo theft. So in terms of assessing the danger, the courts in England are more likely to look at the test laid down in the recent case of the Triton Lark. It's a case that we were also involved. It is a recent High Court case where the courts looked at the meaning of dangerous in the context of Cornwall time clause. It is now safe and clear to say that the test for measuring the risk of attack by pirate is not whether it is likely to be, but rather as to whether the area was actually dangerous. And it is a matter of timing of the master's and owner's judgments. In other words, at the time that the judgment is made, there must be a real likelihood that the place in question is or will be dangerous at the time at which the ship will arrive. And therefore, what we saw after the Triton Lark is the piracy clause, BIMCO Piracy Clause 2013, being revised. The BIMCO Piracy Clause 2013 has also stated, inter alia, and I quote, The owner shall be entitled to take a reasonable alternative route to the discharging port, and if they decide so, immediately to give notice to the charters that such a route should be given. So we have an introduction of the right to the owner to reroute. On the particular topic of the Charter Party Clause, I would also like to mention a UK Defence Club case, the Sultana, that was the first piracy case before the English courts, where the English High Court ruled that the ship which was seized remained on hire for the entire period of the detention. In our experience, in the most recent charter parties, we have intertanko and BIMCO piracy clauses introduced and incorporated, which means that they deal with the loss of hire and time aspect. Another, a P&I case. This is a cargo theft case. It's quite interesting because following the hijacking by pirates of Tema last year, the ship had been acting as a bunker supply ship in the area for nearly 10 years, initially off Luanda. To keep a long story short, there was quite a large quantity of marine gas oil stolen during the hijacking. But this is an interesting case because during the operation of the stealing, the supercargo was able to identify the part of the receiving ship's name and the ship's profile. So when the ship arrived, they reported it to the authorities, and the owners have now brought a claim and a case before the local courts to Cotonou. Watch the space, we'll see what will happen. So in conclusion, when it comes to employing guards on board ships in the West Africa region, do keep abreast of developments in the region, as the position changes constantly. Care should also be taken to ensure that the international group approved version is the basis of your contract. And this is because we have been advised that there is a risk and a danger of homemade, as we call them, versions are outside circulating. And this will alter the liability regime upon the owners and will also have a consequence on the owner's P&I cover. As a closing remark, and contract, following the steps in terms of the contract review, you have to look at your insurance contracts to ensure that there is adequate cover. Charter parties look as to whether the ship will remain on hire during detention. And lastly, cargo issues, check the values of the cargo in case that there will be hijacking, and what will be your exposure also in terms of the cargo theft. That's it. Thank you.